Hi, everybody, and welcome. I'm Leslie with the New Mexico Small Business Development Center. And I love to get on the webinars with Ian Alden, an attorney practicing here in New Mexico, because his information is so valuable for you and your small business today. And I had people all day calling to get into this webinar. So you know the information is so going to be so impactful to everyone. Win-win contracts, negotiate better business deals. I want to remind everyone to type any questions you have into the Q&A. He'll pick them up throughout the entire webinar. We will also send you a follow-up email with the presentation slides and information on what Ian presented today. So I will turn it over to Ian Alden for win-win contracts.
Thanks so much, Leslie, and welcome everyone. It's good to be back here again for another webinar this week. Today, we're going to be going over contracts, specifically win-win contracts, how to negotiate better business deals. Now, before we get started, I've got a few housekeeping notes. First, as we all know, you probably don't need to be told for the millionth time, COVID is still among us. The Delta variant is sweeping the lands, and so it is more important now than ever to maintain a COVID-safe workplace, especially since we're not going back into lockdown, fingers crossed. Everyone is at this point having to reckon with what it looks like to stay open in a COVID world. So with that in mind, this slide has a lot of great resources for you to access on how to maintain a COVID-safe workplace. It'll point you towards up-to-date regulations from the CDC, OSHA, and so on. Highly recommend you take a look at some of these so that you can do everything within your power to be compliant with the latest requirements, advice, recommendations, and so on, because at this point, we're all just going to have to do our part to keep COVID as contained as possible. So some other housekeeping notes, please make sure that your microphone stays muted. It should be muted by default, but on the off chance that it comes unmuted, make sure you mute it. Keep your zoom ratio set to fit window if it's not already. That's so that you can see all of the slides. As Leslie mentioned, we're going to be using the Q&A function to take questions. It's right next to the chat window, but it is a different thing. So be sure to ask your questions in the Q&A. I'll be taking questions throughout the presentation, so don't feel like you need to hold until the end. If you've got a question come up, just ask it. I'll go ahead and stop what I'm doing probably at the end of each slide to take those questions. If you do decide to hold your questions to the end, that's no problem. Just make sure that you write down the slide number your question relates to. You can see it on the bottom right-hand corner of the slide. That is so that I know where to jump back to, so I know roughly what your question's about. So before we get started, I want to draw your attention to some of the other great offerings that the New Mexico Small Business Development Center currently has for workshops. In the next few days, even there's putting your business plan into practice part 2. Are you tax ready? Paycheck protection program, economic impact disaster loans, and employee retention tax credit implications. It's a lot of tax jargon, but a lot of those programs are really helpful. A lot of folks benefited from that during the pandemic, but now it's important to know what you have to do as part of the end stage of those programs to make sure that you're reporting what you need to report. So it's a good webinar to check out as well. 3 steps to attracting and retaining customers. I don't have to tell you why it's important to attract and retain customers. So another great topic. And then next Monday, I'm leading this one on technology, smart, simple tech-focused business strategies. If you want some helpful hints for how to get your business launched or relaunched or revamped or improved in the digital age, check that one out because I've got a lot to cover there. Moreover, be sure to check out the SBDC website, nmsbdc.org, to request no-cost business counseling, loan application assistance, and see the other wealth of resources that they've got for small business owners in New Mexico. Highly recommend making good use of those resources. So this presentation is going to cover contract negotiations, which is a big part of what I do as a business attorney. A lot of what I do, especially because my practice focuses so much on mergers and acquisitions, but also startups and helping people get set up with the right contract with their employees, their contractors, their vendors, their partners, etc. A big part of what I do is helping my clients to negotiate contracts. As a lawyer, I'm almost never in the driver's seat of those negotiations. It's all about what the client wants, but my role is to help them through the process. And so this presentation is going to cover my experience in doing that. It's going to give you a good sense of what's in a contract, what a contract is and what's in it, because this might sound surprising to some and obvious to others, but you can't really negotiate something if you don't know what you're negotiating. So we're going to cover just the basics of contracts. Then we're going to cover some strategies. How do you negotiate? What can you negotiate? How can you mess the negotiation up? And then some other advice that I've got. So without further ado, let's jump into what a contract is. And keep in mind, I've done other webinars on what contracts are, what goes into a contract that are a lot more in depth. This is more 30,000-foot overview just so that you have an understanding of contracts. But I'd recommend, if you want to get a better sense of every different part of a contract, or at least a lot of them, check out some of those other webinars I've done. And I'm sure there's other great presenters with the SBDC who have done similar presentations. So if you go onto their YouTube channel, for example, you're going to come across a lot of those past presentations. So be sure to check those out as well. But fundamentally, a contract is just an agreement between two or more parties in which every party is committing to do something. Occasionally, and as a lawyer, there's exceptions to every definition, every rule. Occasionally, you've got a contract where someone benefits but isn't doing something, but that's usually where you have three or more parties and one is just a passive beneficiary. For all intents and purposes, what we're talking about here, every party to a contract has to do something. They're committing to either provide services, pay money, give property, license something, lease something, do something. Contract has three basic parts: an offer from one party to kick stuff off, an acceptance by the other of the terms, and consideration, which is something of value. Everyone needs to get something out of the contract in order for it to be a legally valid binding contract. And I'll give you a clear and obvious example of where there isn't consideration, so there's no binding contract. Party A agrees to provide services to party B. Party B is doing nothing for party A. Sounds like slavery, because it is, because the party providing services is getting nothing out of it. So it's not a legally valid binding contract for a number of reasons, constitutional and otherwise, but at its core, you have to understand that you can't have a contract between parties without each party getting something out of it. We're going to focus on written contracts. Obviously, negotiation takes place verbally or through emails for the most part, but at the end of the day, we're focusing on contracts that you can put down into writing, because you can have verbal contracts. They do exist. Contracts where not a darn thing is put down on paper, but everyone shakes hands and agrees this is what we're doing. The problem is, if you negotiate a verbal contract, every party is going to come out with a slightly different understanding of what it is they just agreed to. Happens every single time without fail. And even if they didn't have that understanding, relations between the parties breaks down at some point, and then all of a sudden someone's claiming, well, I didn't understand it to be that way. That's why contracts should always be in writing, always. And to that end, let's cover some contract maxims. These are just rules to live by with contracts, because, obviously you can do things differently, but these are just fundamental. So it's important to keep these in the back of your mind as you're negotiating, because this stuff matters. Good contracts, good agreements are made in writing. You don't want to deal with the he said, she said, they promised this, they didn't do the thing they promised, I never promised that. Have it in writing. They should provide clear and unambiguous expectations. So the obligations of both or all parties should be clearly spelled out and, to the greatest extent possible, limited to what's contained in the contract. You don't want the contract to say, so-and-so is going to do this, and 1,000 other things we'll figure out later, because that is just asking for trouble. Contracts should be predictable and enforceable. And what I mean by that is, if you sign a contract, you should know with some reasonable degree of certainty what it is you just committed to do and what happens if you don't do it, and vice versa, what the other party just committed to do and what happens if they don't do it. You want that stuff spelled out in the contract so that you're on notice and they're on notice. Keeps people honest, and it really helps you to avoid those breakdowns in communication or misunderstandings later on. If it's in writing, it's in writing. Some other important concepts to understand as you're going through this process. There's these things called breaches of contract, which is very simply failure to abide by the terms of the contract. If you say, I'm going to pay rent on the 1st of every month and you don't pay rent on the 1st of the month, that is a clear and obvious breach of the contract. You said you were going to do something, you didn't do it. There's this other term called default that a lot of people think is interchangeable, and it's really not. And I want you to understand that, because this does factor into contract negotiations, especially when we get to this thing called a cure period. If you don't pay rent on the 1st of the month, that's a breach, but you're not necessarily going to get kicked out of your house or your property on the 2nd of the month. Most leases, they might have late fees, but they have a provision that says, if you don't pay by the 1st of the month, you're in breach. You have until the 10th of the month, for example, to catch up, to make your payment, to what's called cure the non-payment, to cure the breach. If you don't cure the breach by that 10th day, then you're in default. And default is when a lot of those penalties in the contract kick in. If you look at your average lease, it doesn't say the landlord can kick you out for a breach. It says they can kick you out for a default. So when you're in default, that's when all these other remedies start coming in. That's when you get locked out of your property, and the landlord starts taking stuff to sell it. So that's one of the easiest examples I can think of a cure period, but you actually see these in almost every contract with ongoing obligations. You know, if there's an ongoing obligation to provide services month over month or to make payments month over month, something happens in, 6, 9 months, whatever, after the contract signed, the parties don't want it to just end right there. They want to give the breaching party a chance to fix the breach. And so one immediate point that you can negotiate in a contract, and I'll cover this later, but you can negotiate your cure period. Some cure periods don't exist at all. Some are like 3 days or 5 days. I usually negotiate them out to 15 or 30 days. So that's point one for negotiation, which we'll cover in a little bit here. Frequently asked question. I'm not a lawyer, I'm not contract savvy. Is that enough for me to be let out of a bad contract? I get this probably 3 times a day, and the answer is no. It's one thing if you're a residential tenant signing a residential lease or something. There's tons of state statutes at play that govern and will prevent things from being inserted into the contracts and whatnot. But for business level contracts, especially business to business contracts, the courts are going to assume that you as a business owner are either savvy enough to understand what you're signing, or that you have the means to hire a lawyer or some other professional help so that you can understand and negotiate the contract. So courts are not terribly sympathetic if you sign something you don't understand or didn't take the time to negotiate. So it's really important that you do negotiate, which is why we're here. So let's look at what goes into a contract. Because again, they're really just the promises that 2 or more parties make to one another. Someone's promising to do this, someone else is promising to do that, or pay that, or give this property, etc. But at a very minimum, the contract needs to provide who, what, where, and when. Who the parties are, what they're agreeing to do on, for one another, to another, etc. Give property, give services, money, etc. Where performance will be made, which, for service contracts, it's like pretty obvious, going to be made at this location. Same with employment contracts. Even partnership agreements, they have the principal place of the business listed. Same with LLC operating agreements, etc. The where matters and is very often overlooked, but you want it in there. And when. When is a very important term because, I'll pay you within 30 days of signing the contract is very different than I'll pay you at some point. The when matters. So, what specifically goes into a contract? This is a non-exhaustive list. I swear I could talk at you for 3 hours and not list everything that goes into a fully fledged contract, but I'm going to give you some general ideas of what needs to be in there. You've got who the parties are, why the parties are entering into a contract in the first place. This is in the recital section. Some people skip the why, and you can do that, but I highly recommend having recitals because if the contract goes to court, it helps the court and the jury and the judge to understand the idea behind the contract and the intention of the parties. What each party is going to do, when and how, where and how performance will be rendered, etc. These are all things I just covered, but here's a bit more. This is where things get daunting, and we're going to cover how to negotiate specific points and why they matter, but here's some other things that go into the contract. Representations and warranties. These are things that you are promising are true. You are saying, I represent and warrant to you, the other party, that this is a real limited liability company, that I or this LLC own the assets I'm about to sell you. I have the legal capacity to enter into this contract. I'm not subject to some trust or conservatorship. Think Britney Spears, for example, conservatorship. I'm not subject to something that prohibits me from entering into this contract, etc. Reps and warranties are very basic like that, but they also get very specific in certain contexts. If you're selling your business, for example, there's representations and warranties about taxes. I promise I've paid my taxes. I promise I've paid my employees. There's no outstanding lawsuits against me. There's no outstanding claims against me. These things can be a short list about yay big or a list about 10 pages long. So just understand that's what that section is. And when you're negotiating a contract, you need those to be accurate, because if they're inaccurate, that leads to an automatic triggering of an indemnification provision, which is the next thing. Indemnification provisions are something went wrong. Either I made a representation and warranty that turned out to be false, I breached the contract, I couldn't follow through with my end, someone sued you over something I did, etc. I am promising to indemnify you, which means I am promising to pay for any damages you suffer, including your costs, attorney's fees, etc. I am promising to make you whole. That's what an indemnification provision means. If I'm signing the contract, I'm promising the other party that I will cover them. And so if your representations and warranties are inaccurate and you throw up your hands and say, oh, well, it's good enough, it's not good enough. This is negotiating 101. Make sure that in writing and negotiating the contract, everything that you're representing and warranting is true. There's confidentiality and intellectual property protections. Those go into contracts. That's basically saying, I promise to respect your IP rights and keep stuff confidential. Non-compete and other restrictive covenants. I promise not to compete with you if this is like a business sale or something. I promise not to try and poach your employees or clients. Attorney's fees. If we get into a contract dispute and it goes to court or whatever, I'm promising to pay your attorney's fees if you win, and vice versa. Those typically have to be mutual. The winner gets the attorney's fees. Choice of law. We are going to agree that New Mexico law will apply to this contract because every state has different laws. Choice of venue. We're going to agree. We're going to have all disputes out in the Second Judicial District Court here in Albuquerque, as an example. You pick the venue in advance so someone doesn't go venue shopping. Alternative dispute resolution, which is think arbitration, mediation. We're agreeing instead of going to court, we're going to do this other thing instead to resolve our conflicts. Integration clause, which means this is the entire agreement between the parties. Counterparts, manner of execution, can we each sign this from our houses and then email it to each other? Signature block, it's obvious people need to sign the contract. Notary blocks, if you want folks to get their signatures notarized, you have the notary blocks. Is that a lot? Yeah, it is. And again, this is a non-exhaustive list, but these are all the different things that you can reasonably expect to see in contracts, especially business-to-business contracts. And so it raises the question, you've got all of these things in the contract. Okay, what's up for negotiation? What is negotiable within the contract? And negotiable points in red. You can negotiate who the parties are. For example, if you've got an LLC you want to use instead of you personally, you can negotiate that. You can negotiate the recitals, obviously, explaining why the parties are contracting. Again, it's just a statement for the benefit of whoever's reading the contract, but it's really important that everyone's on the same page about them. So if you're going to have recitals, make sure everyone's in agreement on them. Obviously, you can negotiate what each party is going to do for one another, payment terms, when performance is going to happen, how payment's going to happen, how performance of services is going to be done. This is all subject to negotiation. You can get as creative as you want within the bounds of the law in these contracts. And I'm going to drive that point home. What else is negotiable? Everything else. Literally every point within a contract, again, within the bounds of law, can be negotiated. There's some things you don't really want to negotiate. The integration clause, for example, you typically want people on the same page that, hey, this contract that we're working on is the entire agreement. We're not doing any side deals. It's all in this or in some separate contract in writing. Obviously you want signature blocks, etc. But the point is, and I just want to drive this point home, contracts, they're not rigid take it or leave it things. I mean, depending on the bargaining power of the parties, they might be, but even then, you've got choices to make. You can push back on that take it or leave it approach. You can choose leave it and find another bargaining party, another business partner, for example. You've got power within the process of coming up with your contracts and signing your contracts. So again, literally everything is negotiable within the limits of the law. Some contract provisions are simply unenforceable either as a matter of law or public policy. And I'm going to give you a few examples here. Pretty much all non-competes against doctors in New Mexico are void and unenforceable as a matter of public policy and law. You all remember the doctor shortage from a few years ago that still kind of exists here. The legislature looked into it. They found that one big problem was that doctors were getting into the state or graduating from UNM Med and then they were signing on with an employer who would make them sign this burdensome, like 3-year non-compete. They would say, for 3 years after you leave my employment, you cannot work as a doctor within some huge radius of my practice, which often cut out entire small towns in New Mexico. And they were looking at that and saying, this is a huge driver of the doctor shortage. And so they passed a law that prohibits non-competes against a lot of different types of medical practitioners, including doctors. But this is an example of something that you can't negotiate around. If it's illegal, if it's void as a matter of law or public policy, you don't get to insert a little clause that says, I'm waiving my rights under the law to not be bound by this non-compete. This is something I see people do all the time, and it makes me just, it sounds cool. It really comes off as a jerkish thing to do, but more to the point, you're going to have a hard time, if not an impossible time, enforcing it. So that's something you can't negotiate. Agreements to do illegal things. And this is so fun in the age of state legal recreational marijuana, because I'm seeing all these different contracts pop up between producers and growers and distributors and vendors, etc., to do these things that are eventually, as of next year, I think, going to be legal under New Mexico law, but are still illegal under federal law, because THC marijuana is still a Schedule I controlled substance, and there's entire federal statutes that prohibit the production, trafficking of Schedule I substances, et cetera, the whole thing. But it's begging the question of whether these contracts to do things legal under state law but illegal under federal law are enforceable at all, because the general rule is you cannot contract to commit a crime. You can't hold someone to a contractual agreement to do something that's illegal. And so what happens to these contracts? Does the other party get damages because the other party is backing out? What happens? I don't actually have the answer for you, but I want you to keep this in the back of your mind, that if you're negotiating a contract, do not negotiate to do illegal things without keeping this in mind, and that the contract you're negotiating might not be enforceable. I mean, really, I just recommend don't do illegal things, but obviously that's a very unique oddball situation. And lastly, you cannot negotiate agreements to not comply with legal requirements. And I see this sometimes in employment agreements or business-to-business arrangements, where someone gets it in their head that, hey, if the other party doesn't tell the IRS that I got this income, even though they're required to issue me a W-2, a 1099, et cetera, they're none the wiser and I never have to pay taxes. The hammer falleth hard on all parties to that. That's basically fraud. And so you do not want to negotiate, nor can you enforce a covenant to not comply with legal obligations. So tax reporting is the obvious one. Similarly, stuff with Department of Labor, Department of Health, Workforce Solutions, you name it. If you're dealing with something that's subject to regulations or laws or whatnot, you really cannot negotiate those away at the contract level. So hopefully that makes sense for everyone, because negotiation is so important, and we're about to jump into the actual negotiation section. But just know, as you're going through this and asking, what can I change? What bargaining power do I have? This stuff is pretty much off the table. So now we jump into how should I negotiate? Because negotiation, it requires some interpersonal skills. It requires that you actually be able to develop a rapport with other parties and come up with solutions that that can create mutual benefit and value for everyone at the table. The whole point of a contract is that it needs to create value for all parties. Even if you feel like you're getting the raw end of the deal, you're paying more than this thing is worth, you're still getting this thing. You're still getting the property you're buying or leasing, for example, even if you're paying a small pirate fortune for it. So with all of that in mind, a few things to know before you get started in your negotiations. First, negotiation is something that you get better at over time the more you do it. Your first contract, you don't have a great sense of what it is you're negotiating. So maybe you don't think to ask for this thing that you could get, or this other thing that you could get. Maybe you think you're getting a great deal, and then you go back in a year with more business experience and you look at that contract and say, oh, why on earth did I do that? So just know that this is something you get better with over time. And I'm sure that I'm preaching to the choir to those business owners in the audience who have been doing this a while, because the same is true of anything you do, which includes just general business ownership and practices. So this is something you get better with over time. And it's not a zero-sum game. I went on a long, probably too long rant a few months ago in another webinar about how I hate doing negotiations, because I'm a transactional attorney. I deal with business transactions, which is contracts, negotiation, getting deals done. I hate negotiating against litigation attorneys. Someone hires a family friend who's a personal injury attorney, medical malpractice, whatever, but they do lawsuits, they do conflicts all day, every day. And then suddenly they're asked to negotiate a contract. And they really don't understand that the whole point of a contract negotiation is to create value for all parties, not just yourself. And so I see this all the time where they end up stifling or even killing deals for their clients, saying, well, I protected you because you weren't going to get everything you wanted, so now you're getting nothing. Negotiations aren't a zero-sum game. If you can come out of a negotiation getting everything that you wanted, or almost everything that you wanted, or if you can accept and live with and be happy with what you got, and the other party also got what they wanted, or they compromised, but they're happy with what they got, that is a good negotiation. Obviously, there are sharks out there in the world who really see negotiation as me, 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 and nothing for you. But those are the sorts of deals that are, it's a crude analogy, but I say they're kind of gunpoint negotiations. If there's great disparity in bargaining power between parties, maybe you see that where it's just you're getting the raw end of the deal and they're getting everything, and that's just the way life is. But by and large, approach negotiations with an eye towards the value that you're bringing to the table and what they're getting out of the deal. Use that as leverage so that you're getting what you want and they're getting what they want within some sort of balance. Lastly, know that negotiation can create better long-term relationships. If you negotiate well and you create a reliable business partner who respects you and your negotiation ability, it can create opportunities down the road for more business dynamics, business agreements. You can grow the relationship and grow your own business in the process. What you don't want to do is take a scorched earth approach that gets this deal done, but means that they will never want to deal with you again after. I see this a lot with some clients, and it's just a bad way to do business because New Mexico, it's a small community. It's very parochial in some senses. You can get a reputation very easily in New Mexico and in your towns or cities. And so you really don't want to be known as the worst bargaining partner because folks will look elsewhere for their services or whatnot. So keeping all that in mind, again, negotiations are an ongoing process. It's not just about this deal, but you should be thinking about, okay, what else might I want to do with this negotiation partner in the future? What other opportunities are there out there that I might want to explore? I'll give you an example here. I've got clients who they are in the solar business, and I guess they buy solar panels and then they contract with other parties to install them. And so they negotiated with an electrician or an electrical provider to handle the wiring. Nice and simple. But then that solar provider, a few years later, decided to expand their reach into general energy solutions, which included generators and other at-home grid opportunities. And so they expanded their relationship with their electricians who they've contracted with, and they negotiated another deal and a bigger deal and a better deal that worked out for both parties. So think about how you might grow and expand and how you can pursue future relations and negotiations with this partner. Negotiating tip 2. And this might sound really basic, but I'm telling you, a lot of people get into the process of a contract negotiation and they realize, I really have no idea what I want. I don't know what I'm really looking for out of this other party. And while it's important to keep an open mind about what you might be getting from these people, it's also really important to approach negotiation with a clear sense of what matters to you. What do you need from them? What is it that you absolutely have to get for this relationship to work? Because again, contracts are relationships. Negotiations are about building those contracts and building those relationships. So know what it is that you need from the other party and know what you want from the other party. One great practice is to make a list, just a bulleted list. These are the things I need. These are the would be nice to haves. And then you go and see how much of that you can check off. Tip number 3, and this is huge. This is one of the biggest things I want you to take away from this webinar. Know your value. Because a lot of people think that they don't have leverage in contract negotiations. They think, oh, I am looking for this thing that this other person has or can provide. They set the terms and that's just the way it is. But that's not true at all, because understand what value you're bringing to the table. You need their services, they need your money. You need their money, they need your services or property or whatever. The point is, you have bargaining power even if you're dealing with a party who's larger than you. Maybe about a year or 2 ago, I helped facilitate a sale of a company for $6 million to a buyer worth $6 billion who is operating out of, I think, Virginia somewhere. And you would think, oh my gosh, $6 billion, I'm not going to get a darn thing I want. They're setting the terms, it's take it or leave it, and I'm going to get dragged along through the process. And that wasn't the case at all, because they might be worth $6 billion, but there's a reason that they wanted this $6 million company. There's a reason that they wanted this company that was, a fraction of their value, is because this company still adds value for them. And that was worth them taking the time to negotiate the terms that my client, the seller, was happy with and could accept. There was compromise on both sides. Things took a lot longer because when you negotiate with someone who is that much larger than you, the wheels just turn slower. That's the reality of negotiating contracts at scale. But just know that you still are bringing value no matter who is on the other side of the table. Doesn't matter if they are a brand new startup, they're on par with you, or they just went public with a smashing IPO that raised $100 billion. You've got leverage. Tip number 4, stay positive. And this is so huge. Nihilism or fatalism or doom and gloom, it's just a terrible negotiating position. You have to understand and recognize your value and the leverage it gives you in negotiations. And you have to be willing to accept that you might not get everything you want, but you also have to accept that you might get a lot of things that you do want if you give it an honest try and negotiate. The one thing that will, if you think I'm not going to get anything I want and so I'm not going to bother negotiating, then you're absolutely right. That's a self-fulfilling prophecy. So stay positive in the negotiations and approach it with the expectation that you are going to get something out of the deal. Because if you don't, well, first, again, look for mutual benefit. Again, contracts aren't zero-sum games. The contract negotiations aren't zero-sum games. Some common approaches for mutual benefit are split the difference, or I get this and you get something else. So, if I'm the buyer and I want to buy your business for $500,000, you're the seller and you say, I want an even mill, maybe we settle on $750,000, or more likely we get a valuation and then we go from there and then we throw numbers back and forth until we reach something that we can agree on. Maybe if it's something that you really want and, let's say you're selling your company, and for you to be willing to step away and retire, you need $1 million. That's going to complete your retirement plan. The buyer doesn't want to pay $1 million, especially because what they're getting is worth so much less because you're leaving. Maybe you are one of the biggest contributors to the value of your company. You can negotiate and say, okay, I will sell you this company, or I will sell you this company. You're going to pay me $1 million, but I will stay on for a year and help with the transition. there's ways to get creative, and failure of creativity and creative thinking and problem solving is one of the biggest reasons that contract negotiations go so poorly for some people, thinking I'm limited in this box. These are the things I can do and nothing else. And so I just have to take the deal or walk away. You can get very creative, again, within the confines of the law. Can't hammer that point home enough, but you can get very creative in what you all agree to in a contract. And so look for ways, big and small, to create value for the other side, because any value you create for the other side is leverage for you to get more of what you want. So look for mutual benefit. But then, let's say it's not working out. You're dealing with a negotiating partner who is just obstinate, who says, you know what, I don't need you that much. There's plenty of other folks out there who are willing to sign this contract on exactly my terms. So this is take it or leave it. And that's that. Don't be afraid to walk away. No deal is better than a bad deal, which that saying was really popularized with the Brexit thing from the last couple of years, but that context notwithstanding, it's very true. If you are going to sign a deal that just won't work for you, you can't afford the payments you're committing to, you don't want to be on the hook for the term they're demanding, 10 years, 20 years, whatever. No deal is better than a bad deal in those contexts, because the other part of this is there are other fish in the sea. I had this 2 weeks ago with a client that we were negotiating a commercial lease on, and the landlord for the space wanted my client to agree to replace the roof, the HVAC system, the floors, fix the walls. I mean, this place is a dump. I'm not going to tell you where it is because I don't want to out this property owner, though to be fair, they don't actually live in New Mexico. There's some out-of-state conglomerate, but the place was a dump. And they wanted my client, who was the would-be tenant, to agree to replace all of these things for the benefit of the landlord. My client was going to see none of that money back. The lease was for a 5-year term, and at the end of that 5 years, the landlord is left with a building that is worth substantially more than it was at the start of the lease term. And so the expectation would be that my client would either buy it at that inflated price, or they would pay that much more in rent to rent a space that's worth that much more because my client put the improvements in. You see how farcical this is, and they would not negotiate. I think they have some sort of misunderstanding of the real estate market here because they're based out of state. Maybe that's how it is in Denver, but that's not the way it is here. There's plenty of commercial real estate out there. There's plenty of other fish in the sea. And so I told my client, look, they're not willing to accept any revisions to this lease. They're saying take it or leave it. My recommendation to you is leave it. And they did. And then a week later, they found another space with a lease that was substantially more generous. The landlord was taking on virtually all the repair obligations. It was already in good condition. The lease term was favorable. The payments were better. The rent was better. You see my point here. At the end of the day, if you're dealing with a negotiating partner who won't negotiate, or the deal just won't work for you, don't be afraid to go explore your other options, because the worst thing that you can do is commit yourself to something that is going to blow up in your face and drag you down along with your business, which I think I covered on Monday, this thing about personal guarantees and whatnot. But to the extent that you can be personally held liable for your business's contracts, bad contracts make it that much worse. So don't be afraid to walk away. So fun question that I get, how can I mess this up? And before I even jump into this slide, I want to reinforce the point that you can mess things up in a number of different ways. And we all mess things up from time to time. You're not contract attorneys. That's not your wheelhouse unless you are a contract attorney, in which case I say welcome. Not entirely sure why you're here, but I'm glad you are. But for the rest of you, you're not contract attorneys. You're not necessarily, this isn't your MO, this isn't what you do for a living. And so obviously negotiation is daunting. It's not something that you feel entirely comfortable with necessarily, but rest assured that one of the worst ways that you can mess this up is to not try. So without further ado, a few ways you can mess all of this stuff up is failure to memorialize everything you negotiate. And you remember how I said way back at the beginning of this presentation, the best contracts are in writing. And that's not just true in a general sense where you have a few pages in writing and then a handshake deal. You need everything you negotiate included in the contract, not the least because of that integration clause I mentioned that that says, you know, this is the entire agreement between the parties. It says that, and so anything else that you agree on the side suddenly becomes null and void. What's in writing is the extent of your agreement. So if you agree to something in principle, but then it doesn't wind up into the contract, you haven't really agreed to it in the eyes of the law. You can try and get it added in through the courts, but it's an uphill battle that you're very likely to lose. So make sure that you memorialize everything you negotiate to the extent you want it to be enforceable. Number two, failure to understand what you're negotiating. Again, this isn't everyone's strong suit. It never hurts to have some help in negotiating your contract. I'm not trying to self-promote here. There's so many good business attorneys, contract attorneys out there who can help you get where you need to go with your various contracts. The best of them are going to give you advice and counsel while letting you stay in the driver's seat. I virtually never lead contract negotiations. I mean, I'm going to negotiate the fine print, the details. I'm going to negotiate the language with the other side and with their attorneys. But the actual material points are things that only you can negotiate and decide on. Contract attorneys can help you through the process by helping you understand what you're negotiating and giving you some advice on how you should negotiate in your unique situation. But you remain in the driver's seat. And that's really important to understand, because every so often I have a client who hires me and then says, okay, I've hired you, you take it over. I hope what you negotiate is great. I look forward to seeing an excellent deal. Like, that's not how this works. That is so not how this works. I'm not the negotiator of your deal. I'm just the negotiator of the contract. You negotiate the deal. So failure to understand what you're negotiating can really blow things up for you. So get some good advice and counsel. Again, the SBDC offers no-cost business counseling and assistance, and they've got a great network of resources. So if you don't know where to start with them. Number three, failure to try and negotiate. Assuming that everything is non-negotiable automatically makes it true. If you don't negotiate, you're not going to win anything. And last, agreeing to something that violates your red lines. If there is something that is just untenable for you, and then at some point you acquiesce and say, okay, I'm going to do it, either that's not really a red line for you, or you've just agreed to something that is going to go very poorly for you. So don't negotiate yourself into a corner. Don't negotiate yourself into something that you know you can't live with. Because again, it's better to walk away without a deal than to sign something that you know won't work for you. It's just, I cannot hammer that point home enough, because one of my practice areas that I don't really do so much anymore, but other attorneys at my firm do, is contract disputes. And part of that is one party wants out because they realize that they can't honor their commitments. They can't hold up their end of the bargain. So it's better not to make the commitment than to find yourself in that position. Any other advice? Use your resources. It's really important to recognize that every business owner's situation is unique to them, and every contract is different. So this isn't a one-size-fits-all thing, and this really isn't an, okay, I'm going to go pull this template from the internet and I'm sure it's fine thing. Use your resources appropriately. Again, SBDC is great with their no-cost business counseling and loan assistance and other resources, their network of contacts, their workshops. This isn't the only workshop about contracts. I've led a few already. Hopefully I'll lead a few more, and there's plenty of other presenters who have as well. So figure out what your resources are and make good use of them. That is the best advice I can give you in this process, because then you're going to go into a negotiation armed with so much good advice and so much understanding of what it is that you really need from the deal that you need to come out with. So use your resources. I'm going to use this as a stopping point for Q&A. If people have questions, please feel free to reach out. Otherwise, I'm going to jump back to one of my previous slides and go over some negotiating tips for different parts of the contract. But before I do that, I want to see if anyone has any questions, things they want to bounce off of me. I'm more than happy to take any that you might have. Just throw them in the Q&A. And as I wait for those, I'm going to jump back to the slide I'm looking for. Okay. So, we've got a question. Am I available for a direct consultation? I am, and you can get my contact info from the SBDC. I don't think I included it here in the presentation. I really, one of the rules here is that I really can't self-promote, and I can't promote or recommend any specific service provider. It's one of the SBDC guidelines. The SBDC, again, they've got a great network of resources. I'm one of them. So if you reach out to them, they can certainly get you my contact info, as well as the info for other great practitioners here in town and wherever it is that you're living. Thank you so much. So again, feel free to ask your questions even as I'm going over these points, but there's some very common things that you might want to negotiate, and you really want to look at within your own contract to see, what am I agreeing to? Maybe I want to change that up a little bit. Some common ones, non-compete and other restrictive covenants. They will get thrown into just about every contract, even if they're wholly inappropriate. Sometimes negotiation is striking them, saying, there's no reason why I should be agreeing not to compete with you. And a common example of that is, if you're an independent contractor, let's say you're an electrician, and this one company hires you to provide electrical services for their building, on some ongoing as needed basis. If they have upgrades or other issues, you're going to go out there and provide services for them. But as part of their standard agreement that they give to you, they say, you agree not to provide electrician services for anyone else within the city they're in. That's ludicrous, because you're not, you're an independent contractor, you're a business owner, you provide these services to the general public. They're just one recipient of your services. And sometimes I see this, they throw those non-competes in by default. And in that case, your best negotiating tactic is to strike it entirely. Because really, in that sense, you're not competing with them, first of all, because you're not doing the business that they're doing necessarily, but even generally, you shouldn't be signing a non-compete in that context. Got another question in the Q&A. Oh, thank you very much. Otherwise, maybe you're in a situation where a non-compete is appropriate. Maybe you were a key employee who got a lot of training, or you're going to be, and so you're entering into an employment agreement with a non-compete. You want to make sure that you leverage your bargaining power because they want you as an employee. You want to limit the non-compete to maybe just a few months after you leave their employ, maybe just limit it to their direct competitors, maybe have a list of them that you can't go to work for. There's all kinds of ways to negotiate, even within a non-compete, to make it less burdensome. Attorney's fees, negotiate for it if you want it, negotiate against it if you don't. You don't need to have an attorney's fees provision, but one thing I always recommend in negotiation is, if you're going to have it, it needs to be mutual. If it's unilateral, which means if this side wins a contract dispute, they get attorney's fees, but if you win, you don't. For one, courts really don't like to enforce those sorts of things as a matter of equity, but it's also just obviously unfair to you. So make sure if the other side is getting attorney's fees, you get attorney's fees if you win. That's just fair. Alternative dispute resolution. This is a big thing. Some folks might demand arbitration, and I'm not inherently against arbitration. I actually see a lot of value in it as kind of a lower cost alternative to litigation, since lawsuits can run $30,000, $40,000, $50,000 easy. Arbitration can be cheaper, though it's not always. But if you're going to agree to something like arbitration, make sure it's on your terms. Either have the arbitrators selected by a neutral party, or make it so that you have to agree to the selection of any arbitrator. Make sure that the costs are borne equally by the parties, except for attorney's fees, etc. Make it so that it's not lopsided in favor of one party. Representations and warranties. Again, this is just some basic thing. You need to make sure that they're accurate. And if the other party insists on you representing and warranting something that is inaccurate, don't sign that contract, because you become automatically in breach of it the second you do. If what you're agreeing is in those sections is untrue, you just can't sign it. You really just can't. Let's see here. Some other things that you might consider negotiating. You go back to the very basics of the contract. Let's say purchases and sales. Let's say you want to buy a business and you don't have a lot of leverage, you don't have a lot of capital, you can't pay cash for it. Getting a bank loan is going to be too hard or too prohibitive under the circumstances. You could negotiate seller financing. You could negotiate where the seller agrees that you'll pay them over time as though they were the bank, with a promissory note. You negotiate the interest, you negotiate the number of payments, how long you have to pay. I kind of want to drive home the point that everything is negotiable. And so, I'm going to wrap up here. And I just want to reinforce the takeaways of: you have value that you're bringing to the process. Don't underestimate your value or the leverage it creates for you. Look for ways to create mutual benefit for all the different parties involved. Look for ways to create the win-win outcomes for everyone. And at the end of the day, understand what your needs are in the contract and what you can and cannot agree to. And if this is just a situation that's untenable, feel free, feel confident even to walk away. So that all being the case, if there's no other questions, I just want to thank you all for attending today's workshop. I want to remind everyone of the great resources that are available at nmsbdc.org. Be sure to check out the no-cost business counseling, loan assistance, loan application assistance, other workshops, other training and resources. Thank you all so much for attending.